Hi, I'm Greg Pace with Malek and Malek, and I was thinking about workers' compensation claims for people who work from home. Because while I am an attorney here at Malek and Malek, I generally only come in 2 days a week, and I work from home 3 days a week. Where Kip, you are the employer, but also a workers' compensation attorney, and you generally, while you do work at home, you come into the office 5 days a week generally. So can you go through the law real quick because there was a new amendment in 2022 where Ohio made it a little more difficult to get these claims allowed when you get injured at work. Can you go through it?
Yeah, absolutely. So again, Attorney Kip, so it's Ohio Revised Code 4123.01 and it's injury or disability sustained by an employee who performs the employee duties in a work area that is located within the employee's home and that is separate and distinct from the location of the employer unless all the following apply. So all three of these things must be present in order for you to have a compensable claim. The employee's injury or disability arises out of the employee's employment. The employee's injury or disability was caused by a special hazard of the employee's employment activity. And then the final thing, the employee's injury or disability is sustained in the course of an activity undertaken by the employee for the exclusive benefit of the employer.
All right. So when I read through that, I think arises out of the employee's employment. That's probably pretty easy to satisfy, right?
Probably. I mean, if you're working.
Right. My gut is that special hazard is going to be the main issue. Do you think that's the main issue?
Well, here's the thing, Greg. So I agree that the special hazard is probably going to be the thing that knocks out 99% of claims filed when you get injured at home. But I also think C is also going to be a difficult barrier to getting these things allowed as well. The exclusive benefit of the employer, because that's different from if you're working at your office location. So, and I can give you an example of that if you want.
Yeah, please.
Yeah, so let's just give like a simple example. I'm working at my office, my assigned place where I'm supposed to work, and I have my home and I'm my office, and so I'm drinking and I got to use the restroom, drinking energy drink or water, whatever. I got to use the restroom, and while I'm walking to the bathroom, I trip on a carpet and I break my wrist. Okay, so that would be as far as. Is that the question is, would that be the exclusive benefit of the employer? In that instance, no, it wouldn't be, because as I don't care. I mean, obviously people use the bathroom, but it doesn't benefit me for you folks to use the bathroom, okay? But it would be, if it would happen at the office, it would be a compensable claim, because there's claims that are allowed all the time when people are walking to go to a lunch break and they trip over something. They're going in to pick up a paycheck. That's really not to the benefit of the employer, but those are compensable claims. So versus if you're at home and you get up to use the bathroom, if you're hit with this, that's not to the exclusive benefit of the employer. So then that knocks that one out right away. So that's a simple example.
Okay, so you think the physical act, literal act of what's happening needs to be directly related more to the work and not just incidental to the work?
Yeah, for number C, the exclusive benefit, because that doesn't exist for just run-of-the-mill regular compensable claims. What you're doing doesn't have to be for the exclusive benefit of an employer. And we do this, it's the same, even though you're not applying they call it the totality of the circumstances, the Lord versus Daugherty
right.
Test, but you're looking at proximity, control, and benefit. That's the analysis that's going to undergo if you get hurt, like at the office. Proximity, you're at the office. Control, the employer controls the office location. Benefit, it benefits the employers that employees are able to use the bathroom, I guess.
Right.
So, whereas this knocks that out.
Okay.
Yeah.
What I suspect is if something qualifies as a special hazard of the employment activity, that's going to also be in the exclusive benefit of the employer. My guess is most things that rise to one standard will then rise to that third standard. Do you think?
I mean, I think it would, if you're saying if it would flow logically, if you hit the special standard, it would be the exclusive benefit. I'm probably, yeah. I mean, that kind of makes sense.
What I'm wondering is if, you're using carpenter materials for some reason, you work from home being a carpenter, and that's a special hazard using that, but you're using your work tool for like fun or for home use, then that would no longer be to the employer's benefit.
Yeah.
Right. So that's where it would be. Okay. Well, I still think special hazard is probably what's going to kill most of these claims. So I guess my question is, and this is really a question because we just don't see this. Since in 2020, 2021, people started working from home en masse. So we started seeing claims. Not a lot of claims, but some claims. And since 2022, since this amendment, we don't really see any. And I think the special hazard, because what do you think that really means? Like, how special, how much of a hazard? There's really two parts to it.
Well, I mean, so when you say you're working from home, what does that entail, Greg? Like, what do we do when we're working from home? It's sedentary office type work, right? So we know by the case law that people are going to be like, well, I have to type a lot, or I have to use the mouse a lot. And we know via the case law, if you try to file an occupational disease for carpal tunnel as a result of typing, 99.9% of the time, those are going to be denied. And they might be, if you file in the court, they might be summary judgmented out. And the reason why is because that's not a unique hazard. Everybody types, and everybody types a lot, and that's just the position that Ohio has taken, and probably most states. So what's the special hazard of sedentary work? I don't know. What do you think is a special hazard? And here's the thing, guys, pay attention to this, because Greg is trying to engineer a work from home work injury.
Yeah, because
I'm joking.
No, but I take a lot of our hearings, a lot of our initial allowance hearings. So if you hired us, you got hurt from home, good chance I'm the one that's going to go to the hearing, and I'm going to be arguing this. And this is going to go to a hearing because this will be contested every time. If you get hurt at home, I think Kip's a good boss. If I tell him I got hurt at home, he's going to roll his eyes and say that wasn't a work injury. So what I'm just trying to think through. So let's say, and this is similar to your bathroom thing. If I was here, I trip over my chair, hit my head on the desk. That's not really about work, but that'd be a work injury, unfortunately to you, right?
It's not unfortunate, man. Hey, I'm not going to fight against claims. If you guys fall down the steps, I'm not going to fight it. Now, that's a whole other discussion. It might be the TPA or something that fights it, but I'm not personally, because that happened. But if I'm at home and I've got the office that I only use for work, I've got my desk that I only use for work, my office chair I only use for work, and I'm coming back in, I trip over the chair, hit my head on the desk. I worry that's not special hazard. Yeah,
I would argue in this, you're only in the room for work, you only use the desk for work, you wouldn't have been in there, you wouldn't have tripped. That's what I'm saying in the hearing room, and I'm skeptical that's going to be taken well.
For sedentary work, I just think this is going to kill the amended thing that they have, particularly with that special hazard. If you're working from home and like you do what Greg does, you take a dive and hit your head on the desk.
Right.
What's the special hazard? I mean, because that's an ordinary hazard of, like, that could have happened in your house, and that's kind of what they're looking at. It's an ordinary hazard. So what is a special hazard of sedentary work? I have no idea, dude.
All right.
I have no idea.
All right, so I came up with some hypotheticals. I don't know if any of these are good, so I'm just curious what you think. So there's one in this room. We're not going to put it on camera. I have my work computer, my mouse. These are things that I've used for decades. But I have a portable scanner that I have literally only used for work and only for work with Malek and Malek. So let's say I'm scanning all these documents that somebody gave me, and something happens and the scanner falls off my desk, falls and breaks my foot. Is the scanner that I only use for work a special hazard of working from home for Malek and Malek?
I think the analysis that they're looking at is that a special hazard of the employee's employment activity. And I would argue, and I would imagine most defense attorney, and I'm not a defense attorney, but they would argue it's an ordinary hazard because, albeit that's a scanner that you only use possibly exclusively for work, it's like any other object that's on your desk that falls. There's nothing unique about the scanner. It doesn't have like it's not like trying to attack your feet, and it's live, and it's an object on your desk that fell on your foot. So the question is, Greg, if you had Greg likes to read these giant novels that like telephone book. So if one of your telephone book sized novels hit you on the foot, it's the same thing. It's on your desk and it fell, and that could have fallen on your foot versus this thing. It just so happens that this scanner fell on your
So
foot.
my workers' comp reference book that's 1,000 pages,
Yeah.
and I crack open every day, that falls on my foot, I'm out of luck, because that's too analogous to any other book.
And that's the thing. I think they're saying special hazard of the employee's employment activity. I think that you would argue. I see what you're arguing. This is a special hazard because I have to have this giant workers' comp telephone book. But I would be arguing it's the same thing as any other object. What's different of that versus like Brian Sanderson's compendium of whatever.
Right. Okay. So I agree that one I think would be a tough ask. I would ask it and I would say it with confidence, but I'm not sure it would it'd go through.
I would judge you.
These get more ridiculous as we go. So let's say you're a remote IT guy and you help work on, we've got an IT service. We use a server that's not in our office. For some reason, this IT company has part of the server in my home. That server's bigger than my normal computer. It either overheats, it falls over, something like that, falls, breaks my foot, burns me. That's a server that a normal person would not have, and I only have it because I'm the IT guy, and while working, server overloaded, hurt me. I don't even know that's a thing. I don't know how servers work. What do you think?
Yeah, because I think that's some weird piece of equipment that you have to have. So I don't know if I want to use that IT company that has their server in their employees' office, but I think if that's the case, because it's a weird piece of equipment, and you're like, what about the scanner? I mean, I get it, but that's kind of like everybody has something kind of like that, like a printer or something.
Yeah, the scanner's too close to the printer, where the server is
kind of unique.
Okay.
Yeah.
All right. I think that one a lot of hearing officers would buy. The issue there, I'm not sure that situation actually exists. All right. This one, I don't even know if this would qualify as work from home, but this is just what I'm trying to imagine. You work for an amusement park. You're one of the entertainers. Part of that is you have to dance. You're practicing at home for your job because you have to be on top of things while you're at work. So you're at home practicing and you're on salary, so there's no hours, but you're practicing and you twist your ankle at home in your workspace for work. Is that a special hazard? Is that an employer's benefit? I think it is.
Okay, great. You come up with these examples that are kind of real creative. I'll say that. Creative. I mean, did the employer tell you have to practice your dance moves?
I think it's an expectation that dancers know the choreography.
So that's a requirement of the job, and they're paying you when you're dancing at home, practicing?
If you're salary, I think it's just there's no hours. That's where I think the other issue is. If you're an hourly dancer and you're practicing in your off time, I think the employer's got an argument. But if it's just your shift hasn't started yet for the performance, I think the hearing officers are going to say this dancer was practicing. They were expected to practice at home. They twisted their ankle. This could have happened just as easily in the office. Amusement parks don't really have an office. You're not going to practice on the stage. Makes sense to do it at home. I think that's a special hazard.
This is good. I mean, I think that's good. So for all the dancers who work at amusement parks, you're not affected by this. Okay? But I agree. If you have to...
And I think that's ultimately what my point is the more common your job is, the more common the equipment, this pen's not going to hurt me at home, computer's not going to hurt me at home, paper clips, but the scanner, maybe, probably not. Server, now we're looking at something unique. The dancer, all 12 people that this applies to in the state of Ohio, the odder your situation is, I think the better chance of you getting this approved.
I mean, that's the thing. We're trying to come up with bizarro examples, and admittedly, that's a bizarre example. But I was thinking, what else would there be? Like, you're a pottery sculptor and you have a kiln in your home office garage thing and it burns you. Because I would say, I don't know what job would have you working in your garage doing pottery, but I would say and it's kind of the same idea. You have some weird thing, in this case, a kiln that burns you, but it's almost like the special hazard is linked to the bizarro special job situations.
Right.
And yeah.
And I think the issue is these. I don't think these situations really exist in real life. I think there are people that do work from home using kilns. They're probably self-employed, or they're a contractor. They're probably either their home is their office, in which case they would qualify anyway, because they don't have a physical office, which is part of what the statute says. It has to be separate from the employer's grounds. Or they're a contractor, and again, they're not qualifying for workers' comp. So I do struggle to see many situations in which somebody's calling us saying, I got hurt at home, I work from home, but this was for work, and me saying, yes, you meet all three of these standards.
Yeah, because and what triggered this was there's this thing called Ohio Association for Justice, and it's basically workers' comp attorneys asking for advice on this or that situation. Somebody's like, hey, somebody got hurt and they tripped over a cord or something, and I'm just like, seriously? And I was like, really? But here's the thing, why? So the question is, why was there this amendment in the first place?
Yeah, because 5 years ago, 4 years ago, I had a claim at my previous job that was that exact thing. Lady was working from home. Her printer was on the ground for some reason next to her desk. She got up, tripped over the printer, broke her foot. She had an allowed claim. Ohio looked at this, the legislators, and said, if 40% of our citizens are working from home, we're just going to get thousands of claims a year of people tripping over stuff that they've lived with their entire life, and now it's on the BWC's dime. So now this exists. That same lady tripped over her printer. If she had tripped 18 months later, she was out of luck. She wasn't going to get her claim allowed.
Yeah, and they had claims where people are like walking up, like they're going they're going to lunch, and they're going to lunch in their kitchen. They're walking up the steps and they trip on the steps and they get a meniscal tear. And it's like, yeah, I was going up to my office to work, but it's like, what if you were going to sleep? Going to bed at night and you tripped. Why? What's the difference? So that's and a lot of times when Ohio starts restricting benefits, I'm kind of like that. I don't like that, right? I like things to be fair, but I think with all due respect, I think this is reasonable because that's the compromise, folks. You're working from home and you're kind of giving up some of these things. Whereas if that same injury, you trip over a cord and you bonk your head on the table or whatever at the office, it's a compensable claim. Or you're going to get an energy drink and then you trip, or whatever on the carpet or on the stairs or whatever, compensable claim if you're at the office. So I don't hate this, I guess. I think this is reasonable. But I am an employer. If you're an employee who works from home, maybe you hate this. I don't know.
Yeah, I work from home. I don't anticipate getting injured, but if I do, I'll be looking at this a little closer.
So here's the other thing. So let me ask you this: if this wasn't present, would you guys, and like Greg, because if that wasn't the case and it was like, I'm responsible for you getting injured at home, I would almost want to go to your home office, and I'm assuming you wouldn't like that, but I'd be like, okay, you gotta fix this over here. I want to put padding over here, like this wall decoration. I think that's probably gonna distract you. You might look at that and get hurt.
Right.
And I don't think you would like it if I was going to your house and like child-proofing your living space.
Yeah, that's true. I wouldn't like that, but I also don't like paying for my MRIs, so.
All right, I'll be over there, man. It's a child.
Well, now you don't need to, because Governor DeWine, signed this into law 3 years ago, right around the time that I started working from home while working here. So.
Yeah. So, but I don't know. It's an interesting area law. If you guys have this injury, certainly. Here's the thing: if you had an injury at home, we'd certainly approach it and listen to your injury. But we would not. Here's the thing. This is how we approach everything. We're not trying to see how we could skirt the law. We're trying to see how we could get the law to increase your probability of
Right.
a beneficial outcome. But the reality is, I can't, like, I'm not gonna go into the hearing and be like, you know, you I don't know what goofy situation, but we're not part of fraud. So that's our point, is
Yeah.
to be honest and to have integrity as far as the arguments we're making. At least that's what we do here. I don't
Right.
know. Other law firms, I can't speak for them, but for us,
Yeah.
we try to have some grounded basis. And so, but nevertheless, we would tell you, like, yeah, there's not a special hazard. You tripped over your, you know, cables on the floor. That's not a special hazard.
Yeah.
That's an ordinary hazard, you know?
Yeah, that's true.
So, I don't know. That's my thoughts, but
Yeah, that's it.
that's it. Yeah. So again, at the end of all these videos, remember, workers' comp, whether you have this kind of work from home situation or you have any kind of work injury situation, you absolutely need to call an attorney or attorneys. Don't do this stuff alone, because there's so many nooks and crannies and twists and turns with this Ohio workers' comp stuff that if you do it alone, I'm just telling you, you're gonna run into some headwinds, and it's gonna be to your benefit to at least talk to a workers' comp or workers' comp attorneys. But the other thing is, shop around for the one that you like. Don't go to the one that has the flashiest advertisement or whatever. Ask your friends, families, neighbors, doctors, co-workers, rabbi, imam, priest, preacher, whatever. Like, who do they use? Who do they like? Who do they recommend? And talk to that person. And go with the person ultimately that you feel is going to work best for you and that you're going to get along with. Because the reality is, you guys are going to be stuck together. And if you fire your attorney or your attorney fires you, it's going to be harder to get another attorney to be involved in your case. It's just the reality. So
That's right.
yeah. Anyways, I appreciate you guys
Thank you.
watching this. Thanks. We gotta do a thumbnail. So
Oh, is that what it fucking...
yeah.